ahead and get started because we have a lot to cover today. We're going to do wills and trusts first, and we're going to do some wills multiple choice first, wills administration. Then we're going to do a wills / trust question, essay question, and then we'll finish up with property. Before we do, announcements. Daniel just ran upstairs to pay for his questions. Sarah has asked me to let you know that the deadline is rapidly approaching. In fact, she said I think next Monday, but we need to have them in by Friday. Why do we need to have your money by Friday? We have to batch the orders. Those of you in sales, you know what I'm talking about. We have to batch the orders and send them in. National Conference of Examiners wants us to batch in groups of 5. And she has 4. So now Daniel will make 5. And so those of you who had recent requests, the good news is it'll get processed. But the National Conference of Bar Examiners takes a little while to process, and they need us to give them to give you a cutoff, and you need us to give you a cutoff, because if you don't order the questions soon, you're never going to get around to them. And it's very important to do those questions. So once again, if you want released questions, run, don't walk up over to Sarah and or Susie and get the order in. So that's number 1. Number 2, a request from Missy Gavani, who is the executive director of the Florida Board of Bar Examiners. She's very concerned. You might have gotten a similar email, but I want to really stress it. She's very concerned that a number of people who paid the $125 for use of a laptop have not taken the next step to sign up for ExamSoft. It's a 2-step process. Right, and which will be the same for you, Reggie, when you take the exam. The fact that you pay the money, that's great, that's good, you have to pay it. But you don't get to use your laptop unless you also sign up for ExamSoft, which you must do by Monday, which is the 2nd. It was supposed to be the 1st, but that's a Sunday. And if you don't, they are not giving you any excuses at all. So if you think that you're going to be using your laptop and you haven't yet signed up for ExamSoft, do it immediately. You got to register with ExamSoft, or you won't. You're going to have to handwrite, which, if you're used to typing, is not going to be a good thing. If you have any friends who are not here today, if they're enemies, don't tell them. If you have friends who are not here today, send that message across to them as well, because from what I can tell from Missy, she means business. Okay. Anything anybody want to ask at this point that I haven't that I haven't covered? Some of the other things like earplugs and all that we're going to get to later. Any questions? All right, let's jump into the material. Now, for those of you, it depends on who you had for wills and trusts. I see some folks out there that had my class. If you had my class, you learned Florida law. And if you had Professor Butler, you learned Florida law. If you had Professor Runner, you learned some Florida, some Uniform Probate Code. If you have, anybody here have Professor Gonzalez? No, okay. You also, you know, he's using the Florida book, isn't he now? I don't know if he did with you.
Did, yeah.
Yeah, okay. So the good news is, you had Runner? No. Oh, Menzel. Oh, because he doesn't do just Florida. Yeah. Yeah. Okay. Those of you who had somebody other than Gonzalez, Singer, or Butler, anything that you learned about UPC, out the window. And I will try to point out a few things here as we go along, but I'm not going to point out a lot of those distinctions because you don't want to remember them. When we get to evidence, which we'll do, I think next week, I'm going to point out more differences because you need to know them both. But here, take that UPC, and whoever turned the air on, it was so nice and toasty in here. I know, you guys don't want it toasty, but I do. So let me zip up here because I'm freezing. Put the UPC way behind you and focus solely on the Florida rules. So without further ado, question number 1 in your packet. Thank you. Yeah, come on, we're doing question number 1. We just started.
Probably gonna get that one wrong anyways.
And remember, we're doing just question 1, so click in at the end of question 1, for those of you who haven't yet. And we will do some of these questions. We're not going to do all of them because then it gives you something else to work with. Okay, anybody still working on the questions? Yeah, there you go. We have 20 people in the room, so check your little blue light. Okay, I'm going to call it, but you know, if your clicker's not working, you can get another one. Okay. C is the right answer. So most of you got it right. Let's work through the question to make sure we understand why C is the right answer, although most of you did the right stuff. To do it, what I recommend you do is you draw the family tree. And I know, you're thinking, I don't have a lot of time. I'm under a lot of pressure. I don't have time to draw. You don't have time not to draw. You have to know who's doing what to whom. So family tree in this case. And by the way, you're going to see in these questions that for the most part, they're not in MBE style on purpose. Because the Florida multiple choice questions are like no animal you've ever seen or ever will see again. They are not written in MBE style. They're pretty off the wall sometimes. You do the best you can with them. So our decedent is Dan in this case. He has 3 kids, Raccoon, Nancy, and Doc. So there's your first generation, which of course is going to become very important in Florida. Because in Florida we have what kind of intestate distribution? Strict per stirpes. Not just per stirpes, but strict per stirpes. Which means we're going to look for that root generation, which we'll do in a moment. Raccoon has a kid, Rocky. Then Nancy has some twins, McGill and Lil. Doc's got Gideon, who has a kid, Dakota. Now, when you draw the picture, I know, there's a little Beatles humor there, for those of you who recognize it. Dan is our decedent, and I didn't do this one in color, but usually, those of you who have me in class, the decedent I usually X out in red. Do something to make sure you label your decedent. And Raccoon, predeceased, Nancy, predeceased, Doc, predeceased, which means our first generation, they're all dead. Whoops, I'm sorry. But everybody else is alive. Now, in Florida, strict per stirpes, we look for the root generation. What's the root generation? It is the first generation after the common ancestor. Here it's easy to see. Dan, the first generation after him, he's the common ancestor, his kids. If we're in the second parentellum, the second row headed up by the parents, what's the root generation? Huh. You might have to deal with it. Easy to see when it's children. They're the root generation. Suppose that we've got a decedent with no lineal descendants at all, but with collateral relatives. Aunts, uncles, cousins, whatever, brothers and sisters, collateral relatives. If we're going to the second parentellum, headed up by the parents, goes parents, who comes after parents? Your what? Brothers and sisters, and then your nieces and nephews. What's your root generation? Root generation. Listen to my definition. It's really important. You got to use these tools when you're answering these questions. It's how they'll test. The root generation is the first generation after the common ancestor. The one who gave birth to all these people is the common ancestor. Dan is the common ancestor here, right? Because he gave birth to his kids, who then gave birth to grandchildren. And the first generation after Dan is the children. Easy to see. But what happens if he has no lineal descendants and he has just collateral relatives? Aunts, uncles, brothers, sisters, nieces, nephews, whatever. Collateral to the side. Second parentellum, third parentellum. It's as far as you go in Florida. Second parentellum is headed by the parents. What's the next generation after the parents? Your brothers and sisters. So now fill in the blank. The root generation, if you're going to the second parentellum, is brothers and sisters. It's the first generation after your parents, right? Now, if you have to go all the way to the third parentellum, remember, when you're talking about intestate distribution, you go all the way down that first line, lineal descendants. And if there's nobody, no matter how low you get, great, 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 great grandchildren, whatever, you go up to the top to the parents. No parents, you keep going down, again, brothers and sisters, nieces and nephews, etc., till you get to the end. And then nobody there, you turn around, you go up to the top, headed by the grandparents. And the first generation after the grandparents, which will be your root generation in the third parentellum, your aunts and uncles. So you got to draw pictures because it makes a difference. And they can test you easily on a situation in which the root generation is in a collateral line, second or third parentellum. Now, we go to the root generation, and we assign to the root generation, to each member of the root generation, one part for everyone born into the generation who's still alive, or if that person is dead, who left lineal descendants. So we look at our picture. All three members of the root generation are dead, but we still have three parts. Why? Because they each left lineal descendants. If we took off Rocky, how many parts would we have? 2, right? Because Raccoon was born into the root generation, but he didn't leave any descendants. So everyone born into the generation, the root generation, who is still alive or who left lineal descendants. So we got 3 parts. What does Rocky get? Well, he gets the whole thing that Raccoon would have gotten. McGill and Lil, what do they have to do? They got to split 1/6 each. And then, of course, Gideon gets the other third. Why doesn't Dakota get anything? Because Gideon's still alive, and you cannot take, by intestate distribution, if somebody ahead of you is still living. So even though you all got the question right, look at all the steps you missed. And it's a pretty simple question. You can't count on the questions on the exam being that simple. So you got to be able to go through the steps. Really important. And especially for those of you who might not have spent a lot of time with per stirpe distribution, make sure that you work through the steps. Any questions about number 1? Okay, number 2 then. You got it, Natalie? Yeah, okay. Yeah, you know, stand on your head. I don't know, with these clickers, it's hard to tell. Anybody else? We might have some dead clickers out there. All right, let's see how we did on number 2. Pretty good. Again, because it's a question you've probably seen before, but I want to explain something to you, because this is a simple question, but they might get more complicated. Let's look at our family tree for a moment and talk about some basic points, and then I'm going to give you a little formula. If you like math, you're going to love the formula. If you don't, you can just put your hands over your ears for a moment. But I promise you, the formula that I'm going to give you, if you use it, you will always get the right answer when it comes to half-bloods, and a lot of other people won't. So, mother is married to husband number 1. He's gone. They have a child, Martha. And then mother marries husband number 2, giving birth to 2 children, Rita and Bonnie. Rita and Bonnie, of course, are related by the whole blood. They share a mother and a father. But Rita and Martha, because Rita's going to be our decedent, Rita and Martha are related by the half-blood because they share a mother but not a father. Now, when inheritance, and when we talk about inheritance, we're talking about intestate distribution. If Rita has a will, she can do whatever she wants with her property. But intestate distribution, if you have half-bloods, you have to ask yourself, is the inheritance collateral or is it lineal? In this case, it's collateral, because Martha is going to inherit from Rita. Martha is to the side. She's in the second parentellum. She's not a lineal descendant of Rita. And so the half-blood rule does apply. The half-blood rule does not apply to lineal descent. They can easily trip you up on that. If our decedent, instead of being, suppose Rita predeceased her mother, and then mother dies, leaving Martha and Bonnie. Martha and Bonnie are related by the half-blood, but how much is each going to take if mother's the decedent? Half and half, because it's lineal descent. But here, Rita is our decedent. Martha's related by the half-blood, which of course, under the easy example that we have here, gives her 1/3 and gives Bonnie 2/3. But here's your formula. What you do is, you take all of the individuals who are entitled to inherit. It's a simple answer here, a simple problem here. And each one gets either 1 or 2 parts. If the person is a half-blood, you give that person 1 part. If the person is a whole blood, you give that person 2 parts. So Martha, half-blood, gets a 1. Bonnie, whole blood, gets 2. Add that up. 1 plus 2 is 3. Now you make a little fraction. And this is where people who don't like math just go away for a moment. The numerator of the fraction, top part, is the part that you give to the person. Remember, we gave Martha a 1. The denominator of the fraction is the total. 1 plus 2 is 3, 1/3 to Martha. Bonnie, we put the 2 in the numerator because we gave her a 2 because she's whole blood. Again, 1 plus 2 is 3. 3 is the denominator. If you use that formula, no matter how complicated the fact pattern is, and try it out, you'd be amazed how easy it is to get the right answer. And most people studying for this exam, all they're going to do is memorize this fact pattern. And then, they'll get it right if they get this fact pattern. Change it a little bit, make it 3 or 4 or 5 people inheriting, and they don't know what to do. You know what to do now. And the difference, you get 1, you get 2, you get 3 more questions right than somebody else. That can be the difference between passing and failing. And once again, remember also, half-blood rule in Florida applies only to collateral inheritance. Questions? Just jump in if you have questions. All right, I'm gonna skip 3. You do it. You're gonna get, by the way, at the end, analytical answers explaining all of the questions. But in the interest of time, and also, again, to give you some extra practice questions, we're skipping some. But I would like for you to do number 4. Okay, all in? Let's see how we did. If you know the Florida rule, I don't know what it's trying to find there. Go away. Okay, I'll try to get that back up for the next question. The correct answer is D. We aren't going to be able to compare. How many? Everybody picked D, right? Let's talk it through. Very, very simple fact pattern. We've got somebody who executes a will in 1985 and then tries to revoke the will. Of course, the most important thing in the call of the question is what? Incorrect. Incorrect. You're looking for the wrong answer. So, oh, I know. I see some people. Because I'm watching you while you're doing it, and you're looking. But this one looks. Well, this one looks good. Yeah, 3 of them are good. And that should have told you something right there. If you see 3 answer choices that look really good, chances are good you misread the call of the question. Reading comprehension. So, we're looking for the bad one. A says Billy can revoke by a subsequent writing that declares his intent to revoke and is executed with will formalities. Absolutely. Of course he can revoke in that manner. Then B says he can revoke by executing a subsequent will that has inconsistent provisions. Absolutely. You can have revocation that's express. You can have revocation with inconsistent provisions. Absolutely, no problem there. And then C, he can burn his will. Can he revoke by an act, physical act? No. He can revoke with a physical act in Florida. What can't he do in Florida? Partial revocation by physical act. So revocation by physical act in Florida is absolutely permissible. You have to have the intent to revoke, and then you have to have the act, which is done by the person who's doing the revoking, himself or herself, or by someone at that person's direction and in that person's sight. Case law in Florida actually is more specific on revocation than it is on execution. Execution of a will in Florida, remember, and if you haven't memorized everything, we skipped number 3, which deals with due execution. If you haven't memorized everything, please memorize the following. How do you execute a will in Florida? Okay? You need a writing that's signed by the testator, or it's signed for the testator in the testator's presence, and it is something that's executed by the testator in the presence of the witnesses, or the testator acknowledges to the witnesses a previous signature, and of course the witnesses have to sign in the presence of the testator and in the presence of each other. And that presence, what does it mean? There are 2 tests, line of sight and conscious presence. Florida does not have a case deciding the issue in terms of execution, but Florida does have a case deciding what presence means in terms of revocation. Line of sight test is required for revocation. It's probably required for execution too, although there isn't a case. But Florida, following, we have remnants of the old common law that pop up a lot in Florida, and here's one of them. The Half-Blood Rule is another. No partial revocation by physical act. So if he strikes through part of the will, it's ignored. If he writes something into the will, it's ignored. What does he have to do to revoke the whole thing? He can rip the whole thing up, he can shred it, he can burn it, and burning has to touch the dispositive provisions of the will. And he can even cross out his signature. That would be a revocation in whole. But he can't just revoke a portion by lining it out. So D is wrong. Any questions on 4? All right. Go ahead and do 6. I'm going to see if I can get the program back up. And if I get it up, then you can click in. But go ahead and work the question. Okay. work the questions, it's going to crash on me every time. It worked fine this morning. Obviously, we can't do the clickers, but you can still do the questions. Since I can't track you here, when you're finished, kind of look up or something or wave or whatever, just so I get a sense of when you're done. We still working on it, or are we pretty much done? Okay, a really important question, because depending on when you took Wills and Trust, if you took Wills and Trust with me, I haven't taught the new rule, because the rule just changed. Not for this question, but for trust. Now, we're talking about lapse. And you may have learned, again, depending on when you took Wills and Trust, you may have learned, here's the Wills anti-lapse statute, here's the trust anti-lapse statute, and there were some significant differences, some of which are still there and some aren't. So listen carefully if you didn't just have Wills and Trusts. Let's look at the question. We've got someone who dies testate. It means he's got a will, obviously, and his will, which is validly executed, leaves $10,000 to Beethoven. It's a will. We are applying the Wills anti-lapse statute, which you would probably be more familiar to you. Under the Wills anti-lapse statute, what are the two things we look for to save a gift that would otherwise lapse? Remembering a gift lapses if the devisee either is not living at the time the will is executed or predeceases the testator. So what are the two things we look for? Relationship first. The deceased devisee has to be a descendant of the grandparents of the testator. That's number one. And number two, that person has to himself have what? Well, died, yes. Lineal descendants who can step in and save the gift. So two things. That person has to be a descendant of the grandparents of the testator, and that lapsed devisee has to leave lineal descendants who can step in, per stirpes, of course, and take the gift. Now, before we look at our answer choices here, the new old trust anti-lapse statute, because it wasn't around that long, did away with the relationship requirement. But the new trust anti-lapse statute, effective last July, so you got to know it, now reinstates the relationship requirement. So it's like, what? I can't get. But there is a difference between the two, which I want to point out. And I looked at it again this weekend to make sure that, since I haven't taught Wills and Trust since last summer, I wanted to make sure that that I was remembering correctly. Remember the second thing about the new old trust anti-lapse statute, the one that was in effect before July, that one. Besides the fact it had no relationship requirement, it made all gifts of future interests in a trust contingent, which is not true for the Wills anti-lapse statute. That provision, making all gifts of future interests contingent, is still part of the trust anti-lapse statute. So what does that mean? If you have a gift in a trust to the trustee to hold in trust to pay the income to A for life, and then distribute the principal to B. It looks like B has what kind of a remainder? Vested, right? Because you have an ascertained taker, no conditions precedent. The trust anti-lapse statute turns that vested remainder into a contingent remainder, contingent on B surviving to the distribution date, which is when A dies. So the trust anti-lapse statute rewrites the gift to say to hold in trust to pay the income to A for life, and then to distribute the principal to B if B survives A. But if B does not survive A, then to B's lineal descendants. I'll repeat that. We just rewrite the gift for trusts only, not for wills. Why they didn't make them both exactly the same, I can't tell you, because it doesn't make sense. But anyway, here's what you do under the trust anti-lapse statute still. You rewrite the gift. Starts out to pay the income to A for life, remainder to B. It looks like B has a vested remainder. But we rewrite it to say to pay the income to A for life, and then to distribute the principal to B if B survives A. But if B does not survive A, then to B's lineal descendants, in being at the date of distribution, of course, per surveys, of course.
You mentioned that it had to be now a relative as well. So let's say B is just like my best friend. And
Yeah.
so then it will lapse.
It lapses. So now let's look at our answer choices here. It's exactly right. That's why I wanted to kind of get that out first. We're talking about distributing the 10,000. A says Sadie, who is Beethoven's child, and Mackenzie, who is and Beethoven's our beneficiary or our devisee, whichever the case may be, will share the 10,000 if Beethoven was Jude's brother. Well, if Beethoven, our devisee, was Jude's brother, Jude's our testator, then Beethoven is clearly a descendant of Jude's grandparents. And Beethoven left lineal descendants, Sadie and Mackenzie. And so, yes, they will share. And they would share even if this gift, of course, were created today in a trust. Now, B says Sadie and Mackenzie, again, the children of the devisee, will share the 10,000 if Beethoven was merely Jude's friend. There's the wrong answer, because you need that relationship requirement. Beethoven has to be a descendant of the grandparents of Jude, and the gift lapses, which means it fails if Beethoven is not a descendant of Jude's grandparents. Whether today it's a devise or a trust. This question is a devise, but that rule now applies to both. And of course, if a gift lapses, by the way, what happens? What do we call it when it lapses? It falls back into the residuary clause, or the residuary estate, excuse me, through what vehicle? What do we call it? Well, it lapses, and so and I'm trying to give you vocabulary here, because especially if you get a trust essay, you want this vocabulary. If the gift lapses, it falls back through the vehicle of a resulting trust. Ah, yeah. Vocabulary, important. Resulting trust. Resulting trust always goes back to the testator or settlor or that person's estate. So it's a resulting trust, which of course is not a real trust, but we call it that. And of course, C says Julia, and Julia is the person who was given the residue of the estate. C says Julia shares with the kids of Beethoven, but if the gift does not lapse because it's protected by the anti-lapse statute, then Julia doesn't get any part of that gift, and whether it's a will or a trust, of course. And then D, of course, is then wrong, once again, because it gives Julia a share. She takes only if the gift lapses. Any questions about what I said? I'll tell you, it's important, just as a basic premise, it's especially important now because changes in the law on the Florida portion of the exam, they like to test changes in the law. And just as a heads up, recent changes in the law. When it comes to the MBE, I'm sure they've told you, don't worry about recent cases. And that's true to a great extent because they draft the questions a year and a half in advance. Florida, they do draft them in advance, but they have especially when it comes to the essays, they can tweak the answer and change it, and you can change an answer like this also for the multiple choice. So be aware of recent changes, and in Florida, apply the recent changes in the law. Any more questions on this one before I leave, because it is really important? The answer is A. No, I'm sorry, yeah. Answer is A. And again, for all of these questions, and I have an explanation here that doesn't talk about the new trust anti-lapse statute. I probably should have put that in there. But if you have questions as you're reviewing your materials about that new statute, then let me know. Okay, let's do number 9. How are we doing on number 9? Doing okay? Shall we take a look at it? Okay. Can anybody tell me what number 9 is really about? Pretermitted spouse. Very good. That's as you read these questions, that's exactly what you want to do, is identify the topic, and it is indeed about a pretermitted spouse. Who's a pretermitted spouse? It's a spouse who's married after the will is executed, and your pretermitted spouse can choose to take what? Intestate share, or can take under the will. The spouse gets the choice if the spouse is pretermitted. Now, important, I didn't have a question dealing with spouses' share, which of course changed a few years ago. But think about it for a second. This pretermitted spouse share in Florida, and let me click on the right answer, but we'll talk through them in a moment. Pretermitted spouse share in Florida was always potent, and Florida, when in doubt, Florida has so many family protections, because we've got pretermitted spouse, we've got elective share, we've got pretermitted child, we've got the family allowance, we've got the home furnishings set aside, and we've got, of course, homestead, which we'll talk about when we get to Florida con law. Lots of family protection. And when you couple this family protection with the fairly recent change in intestate distribution, the spouse can walk away with pretty much everything. Think about it for a second. If our decedent dies, survived by just a spouse, of course, and no will, then of course the spouse takes the whole thing. If the decedent dies survived by a spouse and children, all of whom are children of the relationship between the decedent and the surviving spouse. Who gets what today? Spouse gets the whole thing. It's a change in the law, which probably all of you covered. Anybody learn the old rule? Yeah, oh, good, because it's a couple years old now. You don't want to apply the old rule. So the spouse, even if there are kids, can walk away with the whole thing. The only time the spouse gets half today is if there are kids who are from a different marriage. Either the spouse had a child from a different marriage or the decedent had a child from a different marriage. So now this pretermitted spouse can pretty much walk away with the whole thing just by electing. Unless, of course, the spouse waives the right in a prenup, or if the will makes a gift in contemplation of the marriage, or if it indicates an intent to prevent the spouse from taking the pretermitted spouse share. But absent those exceptions, the spouse gets to take the whole thing. And of course here, Garnet can take her intestate share if the will was executed in 1990 and the marriage occurred in 1992. So what makes the spouse pretermitted. Now, one little thing I want to add, for those of you who had Gonzalez or me, or sometimes Butler uses the Florida Wills and Trust book, sometimes he doesn't, pretermitted child. Pretty easy to see usually, except you all remember the very sad case of Patricia Askuntz versus Askuntz. He had a father who had 5, I think, a bunch of kids, made a trust, provided for 4 of the kids because one hadn't been born yet. And then the child gets born. Well, she's pretermitted at this point because she's born after the execution of the trust. But then the father's attorney says, you got some tax issues here. And so they rush a change through in respect to the tax issues, but they leave the rest in place. And then what happens to the dad? 35 years old, dies of a heart attack. Well, fortunately for his wife and the 4 children, he left a nice big fat trust. But Patricia, she's no longer a pretermitted child. Why? Because the will was republished when it was, the will/trust republished when it was amended. And so she was born before the amendment. She is no longer a pretermitted child. So look out for that kind of fact pattern as well. Okay, let's jump forward here. We're going to jump forward a few questions to number 14. Okay, now in 14, this actually is a pretty typical Florida multiple choice question. You know it or you don't, right? You know the rule, you get the right answer. You don't know the rule, you can stare at the page forever, right? Okay, and they ask that kind of detail, sorry to say. In a wills administration, if you have wills administration, which you very likely will have on your exam. They had big fat trust question, as I said before last time. And so I think wills administration is due. It's exactly the kind of question you're going to get. So if we have someone who dies intestate, you still have to have a personal representative. Whether it's testate or intestate, somebody's got to administer the estate. What order do we go in? Anybody know? Surviving spouse first. What's second? Person selected by the majority in interest, what's third? A, exactly right. So it's the kind of yucky detail that you actually want to learn. It's not that hard to learn this one. So spouse, then person selected by a majority in interest, and then heir of nearest degree of kinship. And when we talk about selected by a majority in interest, it's amount. It's not number of heirs, but it's the size of the estate. Okay? Percentage of the estate, yes, then, which is a distinction. Now, what happens if it's a testate estate? Who serves as personal representative? We have 3 again. And in wills and trust, things tend to come in 3s. So if you're struggling and you're thinking, there must be some exceptions or some rules, just think 3. So the first person, if it's a testate estate, will be person named in the will, right? Very simple. If that person can't or won't serve, who comes second? You don't go to the beneficiaries yet, then you go to a person selected by the majority in interest of the devisees. And then if you can't get somebody out of that selection process, then it's any devisee. So once again, if it's a testate estate, you go, instead of surviving spouse, you go to the person actually selected in the will, named in the will. If that person can't or won't serve, then you go to the person selected by a majority in interest, this time of devisees, percentage, when we say majority in interest, and third, any devisee. Okay, number 17, actually an important point, another one of those, you know it or you don't. Let's see how we do. Yeah, question?
I'm sorry, when you said the person selected by a majority in interest, that means their interest in the testate share?
Right, it's how much of the intestate estate would they get? We're talking percentage of the total intestate estate.
And that's for an intestate to see. The testate is
The testate. Yeah, no, it's still your percentage of the total testate estate. So it's the total of the property that passes through probate, whether it's intestate or testate distribution. And so if you've got 5 people, but one has 60%, that person has the majority in interest, right? Okay. Okay, again, we're doing number 17. Okay, again, you know it or you don't, but it's exactly the kind of thing that they like to test. So we've got an estate that's closed. Once the estate is closed and you do your final accounting, it's supposed to be done and over with. And the personal representative has been discharged, which is great for the personal representative. But then we've got a series of questions, and we're looking for the correct one now, the right one. A says administration may never be reopened. Well, you know by now, you have to be kind of cautious about those absolute words, right? So you want to keep reading. A is not the right answer. B says administration will be reopened on discovery of a will or a later will. What do we think? Nope. Once it's done, even if a later will shows up. C, administration will be reopened on discovery of additional property. Aha, that's the rule, which means, of course, D is wrong. If you have additional property, you have to reopen the estate because you got to distribute the property. It's very practical. Okay, we're going to do one last question because most of the rest of the questions here deal with trusts, and we're going to be talking about trust in the essay. But I do have one last question I want to do, which I think is 23. Let me see. Hang on. I think it's 23. Yeah, 23, the very last question. So go ahead and do that one. I see a lot of faces going, And now you may not have you covered wills and trusts? And some of you haven't, some of you haven't. That's, I can never be sure who has. But for those of you who took a wills and trust class, that's all of you, it depends on who your professor was as to how far you got in the book. This question deals with trustee duties. And I promise you, if you get a trust question, you will have to deal with trustee duties. Now, mind you, they did just have a good, big, juicy one, so maybe you get lucky. But I wouldn't walk into the exam without some knowledge of trustee duties. They love to test it. It's so essential, and you may not have gotten that far in your trust class. So let's look at these basic examples. It's the reason why I wanted to do the question, to kind of get you thinking about the types of things that can amount to a breach of trustees' duties. Murphy is the trustee. It's an irrevocable inter vivos trust. Of course, as we're going to see as we go forward, in Florida today, trusts are what unless they're what? Revocable unless they're presumed revocable, unless they're specifically stated to be irrevocable. That's a change. It's not a new change anymore, but it's a very important thing to remember. But this one is named as an irrevocable trust, and Corky is the sole beneficiary. Now, the question is, in which case is Murphy, our trustee, most likely to be liable for surcharge, which means when we say liable for surcharge, it means Murphy breached a fiduciary duty that she owed under the trust. A says Murphy sold Avery Hall, that's a trust asset, to Jim, whoever Jim is, for fair market value without a court order. Now, as we get into the next question, we're going to see that the trustee has very broad powers that are tantamount to the powers of a fee simple owner. And unless the trust dictates otherwise, the trustee is free to sell without a court order. So A can't be the right answer. B says Murphy received a fee for administering the trust. What do we think? How many of you want to serve as a trustee without getting paid? No. You get paid. And there's no problem with getting paid, and quite frankly, all the financial institutions out there that are serving as trustees, there's no way they would do it without getting paid. So the fee is not problematic. C says Murphy purchased from the trust, Eldon Estates, a trust asset for the fair market value without court approval or a trust provision authorizing such a purchase. Can she do that? No. It's called what? Self-dealing. Self-dealing under the current trust code is what we call voidable per se. What does it mean to be voidable per se? It's not void ab initio, but the beneficiary, Corky, can challenge and overturn the transaction without further inquiry. Remember those words, without further inquiry, which means it doesn't matter. She doesn't have to have a reason. I don't like it. Voidable per se. And anything that amounts to self-dealing, buying or selling from the trust, lending money to the trust except in an emergency situation, mortgaging trust, anything that you do for your own personal benefit, self-dealing, and it's voidable per se. If, on the other hand, the trustee sells the property to a relative, it's not self-dealing, but it's conflict of interest. And that conflict of interest is voidable, but it's not voidable per se. And so Corky then has to show that the transaction is not fair. She can avoid it, but further inquiry will be made as to the fairness of the transaction. But here it's clearly self-dealing, and so it's voidable per se. That's, of course, the right answer. D, just a note on it, Murphy hires Frank to serve as an assistant. Today, trustee duties can be delegated as long as you take due care in hiring the delegatee and, of course, in supervising the delegatee, unless it's a function that the trust specifically states is personal to the trustee. Clearly, hiring an administrative assistant is not going to be one of those functions. Okay, let's now jump into the essay. I know we've been working for an hour, but I'd like to get that essay done, and then we'll take a break because subject-wise, we'll stop wills and trusts, and then we can take a break and do property. So what I'm going to ask you to do is pull out the trust essay. What's it dated? February 1994. Flip to the very back, as we always do. Take just a few minutes to read through it and to flesh out some issues, and then we're going to work through that question. And just so that you know, and you can pick them up when we take the break, or you know what, let me just pass them out, because if I don't pass them out, I'll forget. These are the answers to the multiple choice questions.
Thanks.
Did you pick up the answers?
It
Oh.
came in part.
Oh, it came in your packet? Oh, they weren't supposed, they weren't supposed to be in the packet, but that's okay. I'll pass them out anyway. You do have it? Okay. Couldn't remember where I left off. You got it. Yeah. Got you. Yeah, you already. Yeah. Could you put it already? Oh, yeah, sure. Okay. Yeah, we got you already. Okay. Yeah. If you're still kind of working on it, let's try to wrap up. Remembering, of course, that on the real exam you would take much longer. Okay, let's see what we have in this question. Now, sometimes they give you a really easy trust question. And then sometimes they give you this question, which is anything but easy. Honestly, one of the reasons why I wanted to do this question this time is it combines wills administration into the trust essay. Which can be your worst nightmare if you haven't looked at the wills administration portion of your outline. And it doesn't matter who you had for wills and trusts, including me. Most of this boring wills administration stuff, we didn't cover it. The how-to, the process itself. There's only so much time, and we do the juicier substantive stuff. So you are going to need to take a look at wills administration, whoever you had for wills and trusts. So let's kind of go through the fact pattern, and then we're going to walk through the question. Now, you're going to see when you start to look at the PowerPoint that there's a ton of detail in there. I cited statutes. You're not going to put all that on the exam. I put all that detail in there because it can provide you with a really good study tool. And show you how to kind of put the material together should you get an ugly question like this one. So we've got Sam. He's a Florida resident. He dies, survived by his wife and 2 adult children, twins Kathy and Clay. Well, it tells you he's a Florida resident, so you know you're going to apply Florida law. I'm sure, well, I'm not sure, but I would assume in your commercial courses they've also told you that if it doesn't say apply Florida law or Florida resident or property located in Florida, that unless they say federal con law or federal criminal procedure, which they occasionally do, tell them that you're going to assume that the question is set in Florida and you're going to apply Florida law, because it is what they're looking for. So, wife executed a valid antenuptial agreement waiving all claims to Sam's estate. Well, you got to highlight that, underline that, because if she waives all claims, it means she's waiving homestead, she's waiving pretermitted spouse share, she's waiving elective share, she's waiving family protection, she's waiving all sorts of stuff. And we treat her as having done what in respect to Sam, as predeceasing in terms of those rights, okay? His validly executed will, they tell you the will is executed validly. Do not then write a whole page on whether it's validly executed. Now, I see people do that, because didn't I just tell you, if you don't learn much else in this area, learn the elements of due execution. Well, but you just wasted a whole page if you now write what all those elements are. They told you it's validly executed. Just say stipulated to valid execution, I'm moving on. He devises his estate to Tom in trust for the twins. Okay, we've got a trustee, Tom. Kathy and Clay are the twins, and it provides that the trustee is to pay to the twins all income and as much of the principal as the trustee in sole discretion. Ooh, we've got a discretionary trust, right? Deems necessary for the health, welfare, and education of the twins. You have to underline that phrase, because we're going to have to look at what he does and measure it up against his charge. Is he doing what he's supposed to do? Has he stepped outside what he's supposed to do in making distributions? And notice, until they reach the age of 35, at which time the trust terminates and remaining assets, if any, are distributed to the twins in equal shares. Well, you know, as soon as you see age 35, you know the twins are going to want to do what to the trust? They want to terminate early. And as much as it may pain you, and wow, I forgot to put it up. I will email to you, because probably we don't want to take the time to go through the whole chart. I have a handy-dandy, those of you who have wills trust with me, you've seen it, a handy-dandy chart that lays out all the different kinds of ways that you can terminate an irrevocable trust in Florida. It's very complicated. And use your discretion. Learn what you can. I will just tell you it's one of their favorite topics. Another reason why I'm using this question. Again, if I don't get that email to you tomorrow, somebody send me, write it down, somebody send me an email to remind me, because that chart can cut through a lot of the pain when it comes to that topic. Okay, so it's a testamentary trust. Now, I want to beg you, if you get a trust essay, please know the difference between a testamentary trust and a pour-over trust. It's a frequent flyer, the distinction between the two, and people get it wrong all the time. How do you tell the difference? It's actually very easy. A testamentary trust is a trust that's created, guess what, in a will. All of the provisions of the trust are right in the will, one document. A pour-over trust is a will that pours assets into an existing trust, two documents. And of course, for a pour-over trust to be valid in Florida, the trust itself has to be created before or concurrently with the will, and the will has to refer specifically to that trust so that you know into which trust the assets are going to be poured. But don't confuse them, because you just give away tons of points if you confuse the two. Testamentary trust, one document. Pour-over trust, two documents. So in this case, it's a testamentary trust, one document. And the testamentary trust contained a spendthrift clause. They love spendthrift provisions. And the fact of the matter is that virtually every trust today that's executed is going to have a spendthrift provision. So look for it and make sure you can address it. Tom's also named the personal representative, which might not initially say much to you, but what's going to happen is Tom's going to do a bunch of stuff, and we don't know whether he's acting as the personal representative or the trustee when he does it. And so a big part of this question is, if he's the personal representative, he can do X, he cannot do Y. If he's the trustee, he can do X and Y or whatever. The question was designed to compare and contrast. Again, for your purposes, important, because all this stuff about the personal representative in particular, highly testable if you get wills administration, which you might well get. Now, his estate consists of his homestead. Details of homestead I'm reserving for our Florida Con Law question. And of course, I think pretty much everybody came on Friday for Judge Shepard's lecture, so you know the basics of homestead anyway. It's valued at $100,000, $10,000 in cash. City Hospital filed a claim against the estate for unpaid medical bills stemming from his last illness in the amount of $25,000. Now, a little bit later, you're going to see I have it laid out, the order in which claims are paid. It happens to be a topic they love. I don't know why exactly, but I guess it's easy to test. And so those 8 categories, which we'll get to in a moment, try to memorize them in order, because it is something they test a whole bunch. So again, we're going to get there in a moment. Tom liquidated the assets of the estate. Again, we don't know whether he's liquidating as personal representative, as trustee. We'll come back to that issue. And he distributed the proceeds to the trust. He takes possession as trustee and invests all proceeds in a local construction company. Bells and whistles, because he hasn't done what? He has not diversified those trustee duties. The trustee must diversify unless the trust document dictates otherwise. There is a limited provision under the new trust code that says the trustee can choose not to diversify if the trustee thinks it's in the best interest of the trust and the beneficiaries, and of course if the court agrees. But for your purposes, mostly the trustee is going to breach the fiduciary duty by failing to diversify. But the investment is successful, which means that your beneficiaries are likely to do what? Ratify, right? Yeah. They get the choice. They can challenge the investment if they want because it's not diversified, but they can ratify if it's to their benefit. Now, Tom supported the twins from the trust, which he was supposed to do, while they obtained their college education. What do we think? Was he charged to, was that within his charge? Yeah, because it says health, welfare, and guess what? Education. So that one's fine. He paid $20,000 for a life-saving liver transplant for Clay after Clay was in an automobile accident while still in college. What do we think? Yeah, that's his health, right? You gotta, yeah, that's life-saving liver transplant. And then he made down payments on the twins' homes after they graduated. What do we think? Welfare, probably, yeah. See what you're doing. You're matching what he did up to his charge. Now, the twins are 31 now. What did I tell you? As soon as I see 35, I know they're not going to last till 35. And they have successful businesses, and you know they're going to want to terminate the trust. In celebration of Kathy's real estate business closing 2 million sales in 1 year, obviously not right now, or not for most people right now, Tom purchased an automobile for her with $20,000 of trust assets. Nah, can't do it. Even though he spent a bundle, guess what, $20,000 on Clay's liver, he can't then give a corresponding $20,000 to Kathy just for a car. As much as we depend on automobiles to get around, an automobile is not a necessity. So, nope. Now, Kathy assigned her interest in the trust to the local zoo as a charitable donation. Lovely, but spendthrift provision. Exactly right. She can't do it. Or at least not currently, anyway. The zoo gets nothing at this point in time. Kathy Clay and the zoo would like to terminate the trust. Well, zoo has no standing. Question is, can Kathy and Clay terminate? We're going to go through some of those methods. And again, that's what that chart is about, which I will send around to you. The remaining principal balance of the trust is $34,000, which is actually significant. Anybody know why?
You can't,
You think it sounds like one. There is, and again at the bottom of the chart, there is a ground for termination of an irrevocable trust based on uneconomic trust. Two ways to do it. The old way is, and this question was written under the old trust code, if the trust assets fall below $50,000, the trustee in his sole discretion can terminate. Okay. So now, if the trust was funded, discuss administration and possible termination. So let's now take a walk through the answer. And I'm going to take it very methodically. First, yeah, question? I'm sorry?
Yes, the old law you just talked about with the trust code, does that still apply to this?
The 50,000, yes. Yeah, it was brought forward into so there are now two. One is an uneconomic trust if the cost of administration exceeds the benefit that can be derived, which then allows a qualified beneficiary to seek termination through the court, or this 50,000 rule, which gives the sole right to terminate to the trustee. They're parallel. Either one can be used. Okay, again, I'm going to kind of go in order. What does our person who is personal representative / trustee do? First, you got to liquidate the estate. Then you got to fund the trust. So you have to go through the probate process first. And then you can fund the trust. Because as we know with gifts of any kind made in a will, before the devises in the will can be distributed, what do you have to do first? Pay all the creditors, right? Got to satisfy the debts first. And so we have to go through that process, get our personal representative up and running, get him letters of administration, and then he can liquidate the estate, distribute to any beneficiaries, in this case, fund the trust. Then we're going to administer the trust, And then we're going to terminate the trust. Now notice, if you get a trust essay, you might, probably not, but you might. We have a nice sort of arc to any trust essay. That's the good news. First thing you have to do is create the trust. And that would be talking through some of those issues of trust creation, you know, the settlor and the beneficiaries and the trust race and all of those things. Then if you have a properly created trust, you're going to have to administer the trust. It includes all of those trust provisions that we're going to be looking at, and of course trustee duties. A big part of the administration is likely to be trustee duties on the exam. And then they usually wrap it up with a question about termination. And all trust questions are going to kind of go in that order. All right, so let's get that up. And let's liquidate that trust. Now, what I've done here, honestly, I don't know how much time you would have to go through everything I've gone through here. This is a huge question. But again, for your study purposes, I'm going to go through it first with Tom as the personal representative, and then second with Tom as the trustee. Because they're kind of fuzzy on that, I think, on purpose. You might have to pick one, as we talked about in a number of questions, and run with it. So if he is the personal representative, and he was named as the personal representative. So the question now becomes, was he authorized to act? The first thing that the personal representative needs to do, and some of you may know it from your wills and trust class, but more likely maybe from personal experience, you have to get these letters of administration. It's what authorizes the personal representative to act. Anybody that you deal with, vendors or other people that you deal with, they're going to want to know that you have letters of administration. And sometimes a personal representative will act without them. Well, if you act without letters of administration, technically you don't have power to do whatever you're doing. And what did Tom do in this case? He sold whatever it was called. What was the name of the estate? Whatever it was. He sold the property, real property. So he didn't have the power. If he doesn't have letters of administration, he doesn't have the power to sell the property. Of course, once he gets the letters, then it relates back. And so the letters will backdate, if you will, to cover the sale that wasn't proper in the first place. So if he has letters of administration, then he can go about his business. But important to this case, really important, is how much can he do? Now, a personal representative has a lot of powers, but they aren't as great as a trustee. And sale of realty is one of those places, easy to test. They do like to test this particular point. They could do it either in essay or multiple choice. To sell real property, a personal representative needs authorization in the will. The will has to specifically authorize the personal representative to sell the real property or have a court order. One of those two things. Otherwise, the personal representative does not have the power to sell real property. Well, there's no court order here. Tom just sold the property, and we don't have anything express in the will. They don't tell you that Tom was given the right to sell without court authorization. So his sale is problematic. And add to that an additional problem. Because even if the will, because remember it's a testamentary trust, even if the will gave Tom the power to sell real property without court authorization, remember, it's homestead. Court order is required anytime homestead is sold. So any way you slice it, his sale of the homestead is really problematic. And if it's improper, again, a really important contrast between acting as a personal representative and acting as a trustee. If he sells the property improperly as a personal representative, title does not pass, period. End of story. Purchaser's out of luck. Unless, of course, your beneficiaries ratify. They can always choose to ratify. And I think it looked like it was a good sale. Kathy and Clay might say, that's okay, we want the cash. But absent that ratification, no matter what, the sale doesn't go through if Tom acted as a personal representative. And of course, if he acted improperly, he does, even as a personal representative, have a fiduciary duty for the breach of which he may be liable. Yes, sir.
On a question like this, that there's really not that many assets, would you think that we should still look that way? 'Cause I would kind of like skip on this.
I wouldn't skip because, I'll tell you why. We're going to go forward. And remember, it's the sale of the homestead. And you got to talk about the sale of the homestead. And if he was acting as a trustee, we have a different ballgame to a certain extent. He's acting as trustee. Trustee has powers, as we said before, tantamount to the powers of a fee simple owner. And a trustee, as we saw in one of the multiple choice questions, can sell real property without a court order unless the trust provides otherwise. So big distinction there, personal representative versus trustee. Now, mind you, let's see where I can find it. Homestead, wherever it is, okay. Well, anyway, homestead, we still may have a problem because even if it's a trustee, the homestead is going to require court order because it's homestead. Now, if our trustee, if Tom is acting as the trustee and he sells the property without a court order, here's a big difference. If he's breached his fiduciary duty, the sale is still valid. He may be liable for the breach of the duty, but the sale goes through and the purchaser gets to keep the property. Big difference. That's why I would talk about it. Because the purchaser, if he's acting as a trustee, even if he's breached his duty, gets to keep the property. But if he's acting as a personal representative, the purchaser doesn't get to keep the property. And they clearly put that in the question. It's certainly in those facts. Could you get a passing score if you didn't talk about that particular issue? Well, if everything else is good, yes. But I wouldn't just skip over that kind of stuff. Really sit and think about what's going on. Remember, on the exam, fact pattern, while Florida does not follow the MBE rules for multiple choice questions, it does follow the MEE rules, multi-state essay exam rules, for writing essays. Can't tell you why, but that's the case. And MEE rules, very short fact pattern, to the point, every fact counts. So I sit there and I say, what's that fact doing there? And in this case, that's what the fact's doing there. So remember to make that distinction in your mind. Certainly could come up on multiple choice. You see it even came up in an essay. So just a conclusion there, which you can read. Now, funding the trust. We've got a devise of the homestead, bells and whistles, right? Because you're remembering what Judge Shepard said. And general rules, okay? Homestead is not generally subject to devise if the decedent is survived by a spouse or, not and, or a minor child. If the decedent is survived by a spouse, then of course the decedent may devise to the spouse. But in this case, we've got, the wife is still living, but what'd she do? She executed a valid antenuptial agreement in which she waived all her statutory rights, which includes her right to homestead. And so we treat her for that purpose as having predeceased. So he's survived by two, for the purposes of homestead, he's survived by two adult children. So can he devise to whomever he chooses? Yep. So he can devise the homestead to the trust. and a little bit about antenuptial agreements. I wouldn't spend too much time talking about it here. That's one thing, unless they give you a lot of facts. They said it was valid. I would just say it's good. Okay, now, we have to fund the trust, but before we can, we've got to pay those creditors. Don't forget about them. They're standing there first. They get paid first. Here's that order of payment that I mentioned. Do you memorize it? Yeah, I would if I can, only because they test it over and over and over again. Interesting list. What do we pay first? We pay ourselves first. Lawyers get paid first. What can I tell you? We take care of our own. That's class 1. Class 2, reasonable funeral expenses, of course not to exceed $6,000. Now, somebody's got to get into that statute and update it, right?
Yeah.
So how far does, I hate to say it, $6,000 gets you no place with funeral expenses today. And remember with these classes, even though $6,000 doesn't get you very far, it's class 2, it gets paid first, but the excess falls down to class 8. So it doesn't mean it doesn't get paid, but that part of the claim gets paid later. Class 3, I find this particular point, there are some other things in here, but this is good enough for your purposes in class 3, debts and taxes with preference under federal law. It's a slightly larger category, but that's what they'll test. And what I find really interesting about that particular category is it's class 3. Taxes, the IRS, they're actually subordinate to guess who? We, the attorneys. It's the way it's drafted. Class 4, important class, and it's the class, of course, that's applicable here, reasonable medical expenses for the last illness for the last 60 days of the last illness. Anything that exceeds the last 60 days, what happens? Drops down. Susie's here. You know what? While she's here, did I get everybody? I'm going to mix them up since she's here so we can, and Susie's going to draw today. She's our guest drawer. So blame it to her, yeah, blame it to her. Okay, who we got, Susie?
Next.
No name.
No name.
That may be mine. I wrote in red ink.
Let me see if it is.
Is it?
No, this one's completely,
Blank.
wait, no.
Oh, I forgot to put mine.
I can't see anything. I don't think this is yours because I don't see anything
There's
on it.
nothing on it.
I'm trying to read it. Okay, next. That's your fault if you don't write your name on it, right?
Sylvia?
Where's Sylvia? So,
Sylvia?
Daniel,
Oh,
Daniel,
sorry.
it's Daniel, yeah. Okay, Daniel, congratulations. Yeah, I'm thinking Sylvia. I don't know everybody's name, but
I don't.
it's Daniel over there. Okay,
Okay. The tennis shoe?
congratulations, Daniel. Come back next week. When is the next one?
Thursday.
Thursday.
I mean, Monday.
Monday. Oh, Monday.
Monday, Thursday, which day?
Monday is civil procedure. Oh. Part 2. Yes. So please do come back Monday for civil procedure part 2 and another chance. Now, let's get back to the question so we can get out of here at some point today. So class 5. Family allowance, $18,000. I don't have that up there, but the family allowance is $18,000, right? And the family allowance is paid to the surviving spouse, not in this case, of course, because she waived, and lineal ascendants or descendants. Interesting. It's ascendants, meaning parents, grandparents, or descendants that the decedent is actually supporting or is obligated to support. That's nobody in this case, so nobody actually could claim the family allowance in this case, but that's class 5. Susie, thank you very much. Number 6, the newest category, court-ordered child support, any arrearage in it. 7, debts acquired after the death by continuing the business, which can be done for 4 months without court order. Then you need a court order to continue. And then finally, your catch-all. Anything else, including the excess in 2 and 4, the funeral expenses, and the last illness. Once again, I would try, if I could, to memorize this list, which you may not have seen in your wills and trust class because it's, again, it's that boring administration stuff. So what do we do here? Hospitals claim 4, and they like the numbers. It's class 4 claim and would be for the last 60 days. They didn't tell you specifically that it was for the last 60 days, so you just make that qualification. Okay, we'll see you tomorrow. Okay, now, I have a little bit, and I'm not going to read through all of it so that I don't bore you all. And kind of going back to your question, how much of this would I put in? The procedure? Nah. As much as you can kind of spill out, but without going into great detail. I would spend time, I will tell you, I would spend time kind of getting the sense of the procedure, how the claims are paid for the purposes of the multiple choice. How much of this I would write out on the essay? Yeah, I don't know. But anyway, I would at least do the math because we got $10,000 in cash, $100,000 from the sale of the homestead, assuming that they ratified the sale of the homestead, which the adult twins probably would have done. We back out the $25,000 from the last illness, that leaves us $85,000 to work with. Simple math, but I would take the time to do that much. I'm going to skip past all this stuff again on objections. Review it yourself. You can read what I have here. It's not a bad idea to have some understanding of it. Okay, and we can skip my conclusion. And now let's administer the trust. Really important part of the essay. We've got some meaty issues that they love to test. They love to test diversification or, quite frankly, failure to diversify assets. It's a frequent flyer, which of course happened in this case. The liver transplant is, as we said, not going to be too much of an issue. The college is not, the down payment, but of course we're going to get to the purchase of Kathy's car and her attempt to transfer her interest to the zoo in the face of the spendthrift provision. And they love to test spendthrift. Wow, it's an even more frequent flyer than anything else in trust essays. So we can kind of go quickly through this. Remember, diversification is all part of this prudent investor or prudent trustee rule. You have to act prudently. And part of it is diversification. Tom put everything into one business. He did not diversify. It's improper because the trust document, the will, which contained the trust document, did not authorize him to do so. And there's nothing in the facts that suggests that he thought it was necessary under the circumstances. But there's no loss, so I'm guessing the beneficiaries would ratify. Now, next up is the liver transplant. Goes without saying. He's authorized. It fits within his discretion. What about supporting the twins? Same thing, so we don't have to spend too much time on it. Notice, by the way, though, it's in his sole discretion to determine, and he can use his discretion, but of course he has to operate always in good faith. Goes without saying. Everything the trustee does has to be done in good faith. Down payment, same issue. What about the car? As I said before, the car doesn't really fit, and a car is not a necessity, so she's not getting her car. Notice what I've done here and what you want to do on your essay. I've taken each of the events and I've analyzed each separately. It's a whole lot easier to follow the answer if you don't just take all of the events and try to mix them all up in one big paragraph, one by one, march through them. Sure, it can end up in short, simple paragraphs, but it's a lot easier for you to write. It's a lot easier for your grader to go check, check, check if you separate them out. Yes, sir?
Are never a necessity? Is that like a bright line rule?
Well, I'm not, never say never, especially when it comes to the bar exam, but almost never. Think about South Florida. I came in this morning to teach ALS. We got some ALS students in here today. And I gave myself nearly an hour. I stayed at home just long enough to check the traffic, which said there are no accidents. By the time I got to 95, huge accident. And I got just 9:30, I rolled in. It took me almost an hour for a drive that takes 25 minutes usually. How else was I going to get here? I'm thinking, I got to drive my car, right? No. How else can I get here? God forbid I take the bus, but I can take the bus, right? Okay? Can't take a cab, call Uber, you know. I can't take the train. Some of you may take the train, you know, if you're coming from north, I can't take the train. But
Speaking of things, like, okay, so they have successful businesses and things like that.
Yeah.
Something about them not needing the income because they have their own businesses. Isn't there something about that?
that goes to termination. They're showing that the purpose of the trust has been fulfilled, which is a ground
Right.
for termination. We're going to get there. But that's good reading of the facts. You want to look at those facts and say, why did they put that back there? And that's why they put that back there, which we'll get to. We're almost done with this question. Impartiality. And that's the tough one here, because honestly, remember, the trustee has to treat all beneficiaries equally, and they do like to test impartiality, because they'll have a trustee who who maneuvers the trust race in a way that benefits one beneficiary more than another. And Tom was trying to be fair. He spent $20,000 on Clay's liver transplant, so he's thinking, I got to spend $20,000 on Kathy. But he can't, because he is actually favoring her by stepping outside his charge, and he can't do it. Now, what about the spendthrift provision? First of all, of course, spendthrift provisions are valid in Florida. Everybody knows that question?
Yeah, just one or thing the typo here.
Okay.
To find a way to counter-argue the impartiality aspect here, what would be a good tactic? Maybe to perhaps make an argument that because Kathy approached him to buy the car, that maybe it kind of waived the impartiality in arguing.
Well, she might, but Clay, that's the problem. It would be tough unless Clay ratified, and he might. And so maybe you put that in there and say, Clay, if Clay realized that he got $20,000 more than Kathy, he might ratify. You could put that part in. But otherwise, she can't ratify her own benefit. Yeah.
I'm not ratified.
Exactly. And once again, it would be just really tough, even here in South Florida, where public transportation is really bad. It would be really tough for her to claim the car as a necessity. You know, walk. I don't know. Well, you can't walk all the way up here, but there are other ways. So, spendthrift provision valid in Florida, of course, as long as you're attaching it to somebody else's interest. You can never protect your own interest with a spendthrift provision. But honestly, that's so basic that I can't imagine that they would test that particular point. If there's a spendthrift provision, then you can't transfer your interest as a beneficiary. You can't transfer your interest voluntarily or involuntarily. Involuntary transfer means a creditor is attaching. Of course, Kathy is trying to make a voluntary transfer here. What they usually test is the involuntary transfer, a creditor who reaches. And we'll get to that in a second. Limited exceptions. Now, there are 3 in the statute. They are different from the common law. In one in particular, they left off, and they apparently left it off on purpose. So here are the 3 in the statute. Alimony or child support, remember, only as a last resort after you exhaust your traditional remedies, primarily garnishing wages. Number 2, a judgment creditor who's provided services to protect a beneficiary's interest. That might be an attorney, for example, who protects the interest. And 3, claim of Florida or the U.S. Taxes, Medicare, government. In fact, there's a lot that's been written about it that suggests Medicare, Medicaid, which sometimes requires reimbursement, that this particular prong was aimed at that. What's missing is necessities. Previous law also had an exception for necessities, anyone who provides necessities to a beneficiary. That provision is missing from the statute, and from everything that we can tell, it's missing on purpose. So that exception's probably not there anymore. So Kathy's out of luck. She can't transfer to the zoo right now. Now, if she gets the cash, she can then donate it to the zoo. No problem with that. Termination of the trust, which I'm going to summarize. There is so much detail here. Learn as much as you can. I hate to say it, but they do love to test the topic. But wow, the rules are really dense. Again, I will circulate to you that chart because it's probably the best way to learn what's going on. Distinguish between judicial and non-judicial modification. Judicial, obviously, the court is involved. Non-judicial, the court doesn't have to be involved. The parties can just get together and do it. Understand, of course, that even with non-judicial termination, they usually end up going to court anyway to be on the safe side. Common law. The statute expressly preserves common law termination of a trust. And remember, when we talk about termination of a trust, we're talking about termination of an irrevocable trust. A revocable trust, who gets to terminate it whenever he or she chooses? The settlor. And a revocable trust, a trust that's revocable during the lifetime of the settlor, automatically becomes irrevocable when the settlor dies, right? So an irrevocable trust could be one that is stated from the beginning to be irrevocable, or it could be one, in this case, testamentary trust has to be irrevocable because our settlor is dead, or one that starts out revocable but becomes irrevocable when the settlor dies. So there are a couple of grounds for judicial modification. First is if the trust purpose has been fulfilled. Going back to the point, these kids are not kids anymore. They have successful business. They're going to say that the trust was set up to protect them while they're kids. There's no point left in keeping the trust open. And maybe they're right. Who can challenge? I'm not going to go into detail on who's a qualified beneficiary, but they have to be qualified. Kathy and Clay, just suffice it to say, they are qualified beneficiaries. If you have questions as you review your outline about what a qualified beneficiary means, you can certainly ask me. Qualified beneficiaries have special rights, and in respect to termination of trust, that's one of the main areas where they have special rights. And Kathy and Clay, they're current beneficiaries. They would be qualified beneficiaries, which means they have standing to seek termination. The question is, would they succeed? They might. They might. Now, the only thing to take into account here is the fact that there's a spendthrift provision. Under the common law, if a trust had a spendthrift provision, that's it, you can't terminate. Under the statute today, the court will consider a spendthrift provision, but it's not dispositive. It's just one of the factors the court takes into account. Second is best interests of the beneficiaries. Now, this particular vehicle is used primarily when there's been some major change. Say, for example, Clay. Instead of getting that life-saving liver transplant, he is deathly ill and they can't find a match. His circumstances have changed substantially. He needs more money now. Best interest of the beneficiaries. There are a lot of extra rules that attach to best interests of the beneficiaries, including a component of the dreaded rule against perpetuities. I am not going to go through all of that right now because I see a lot of tired faces and it's probably too much information. But unless there's anybody who wants to spend some time talking about the rule against perpetuities, I didn't think so, okay? So just be aware that the rule against perpetuities, I told you, this is a tough area and they love to test it. Rule against perpetuities is relevant to a lot of these methods for termination. Not the first one, but this one, judicial modification as well. So just be aware. So I'm going to go past that because there's your perpetuities. Read it. If you have questions, let me know. Once again, that spendthrift provision to be considered but not dispositive. Non-judicial, without the court. If you have unanimous agreement of the trustee and all qualified beneficiaries, they can get together and terminate. And by the way, when I say terminate, this is just about termination, terminate or modify, because the rules are the same for modifications. They can get together and do it, which is different from common law termination. I'll show you why in a moment. It's, once again, the settlor has to be dead, which of course is not the case, sorry, it is the case in our case. Settlor has to be dead, and they have to all get together with the trustee. And certainly Kathy and Clay want to do it. Maybe Tom agrees. Maybe, he says, I've had enough of these two kids. Spendthrift provision, it is considered again. It's not dispositive, but I'm not going to go through it in detail. There's a perpetuities component again. So if you could even just say that, it gets you some points, right? Without having all the detail, and there's a lot of detail here. Now, termination by all the beneficiaries. Remember I told you that the common law rule has been incorporated into the statute. So under the common law, the beneficiaries could get together with the settlor if the settlor was still alive, or obviously without the settlor if the settlor is dead, to terminate the trust if there's no further purpose to be served. Who's missing from this equation? The trustee. Look at the difference. Statutory termination by unanimous agreement means all qualified beneficiaries and the trustee. Common law, if the settlor is dead, all beneficiaries. Without the trustee. Trustee has no say. But the trust cannot be terminated if there's a trust purpose left to be served. What do you want to look for there in terms of a trust purpose to be served? Two things, both of which are in this question. The first is a spendthrift provision. In contrast to the rule for termination under the statutory methods, there you consider the spendthrift provision, but it doesn't control. If there is a spendthrift provision, then common law termination is not possible, period, end of story. The other thing you look for, also present in this question, age limitation. If there's an age limitation, as there is in this question, age 35, the beneficiaries who are under that age cannot terminate at common law, period, end of story. They might be able to terminate despite the age limitation under the statutory method, but they cannot terminate under the common law method. So here, common law termination, it's not available to them, which means that if they've got a problem, if Tom doesn't want to join in, then consent's not going to work. Now, going back to the question that was asked, a couple of people asked about earlier, your uneconomic trust. There are two methods for termination. First is the old statutory method. It's a statutory method that predated the current statute, which gives the sole discretion to the trustee. Once again, the trust rate falls below $50,000, which is the case here. And the cost of administration is so high that it impairs the value of the trust. So, which is probably something that would be granted in this case, because the assets were down to, I think, $45,000, if I remember correctly. 34, I'm sorry, yeah, 34. Think about $34,000 and gets you no place today. So Tom could step forward and ask the court to terminate, and the court would probably grant it. Even if you've got a spendthrift provision, unless there's a provision in the trust that says absolutely you can't terminate on this ground. Last method is the uneconomic trust, the new version of uneconomic trust. This time, trustee or qualified beneficiary, as I mentioned before, can terminate or can seek termination, apply to the court, And once again, if the cost of administration outweighs the value of the trust, then either the trustee or a qualified beneficiary may seek termination. Same thing in respect to spendthrift provision. And likely, if anybody asked the court to terminate this trust, it probably would. Questions? So, see, it's kind of scary what they pack into these questions. Do you have to write everything I talked about here to get a passing score? Yeah, no. And honestly, I couldn't write all this stuff in an hour. So you kind of do have to pick and choose. Pick and choose based on what the facts are just screaming for you to discuss. All right, let's take a very brief break because I'd like to get you out of here by 6 o'clock if I can, out into, of course, rush hour traffic. And the property essay should not take real long, but let's be back, as soon after 5 as we can. I know it takes a few minutes to walk out and shake the cobwebs. Okay, folks, let's go ahead and come back together so we can scatter. Before we get into property, Natalie asked a good question on the break, and I was trying to, like I said, trying to avoid all things perpetuities just because it makes people crazy. But it's a point that really does, it needs to be made if you go back and review your materials and you look at what I had in this handout and what you'll see on the chart. Reggie very kindly is printing the chart for everybody, so you'll get a copy in a moment. Your materials very clearly tell you that any interest created in a trust after December 31st, 2000 is subject to the 360-year rule against perpetuities. And yet that chart says 90-year rule. So here's what's going on. When you measure the validity of an interest created in a trust, as long as it's after that date, which it's almost certainly going to be for your exam purposes, you use the 360-year rule. But when we talk about termination of the trust, thank you. Yeah, just go ahead and, it's a different ballgame because what happened was in drafting, I'll get your question in a second, in drafting the statute, the drafters said, settlors, if you want to foreclose your beneficiaries from changing your trust after you die, which you can do by setting it up properly and following these rules, you've got to be a little more careful in your drafting. And you have to draft it so that it satisfies the 90-year rule against perpetuities rather than the 360-year rule. So you're using the 90-year rule in trusts only in respect to the power to terminate the trust. You use the 360-year rule for trusts, again, as long as it's created after December 31st, 2000. You use the 360-year rule to measure the creation of the interest in the trust. And of course, anything created outside of a trust, you still use the 90-year rule. So your question?
Yes, with regard to the 360 for Raptor Trust, does that apply to the wait and see just like it was for the 90?
Yes, exactly right. It is. That's a good point. It is the same wait and see. So honestly, I don't know about you people. I don't think turtles even live that long. Turtles live a long time, but they don't live that long. Wait and see for 360 years, forget about it. And so practically speaking, the rule against perpetuities is largely dead in Florida. But don't say that on the exam. Even though it's true, still wait and see 360 years. Question?
Yeah, Brian had asked me a question yesterday that I didn't know.
Okay.
We're talking about it now. The possibility of
Possibility of reverter?
possibility of reverter. RAP doesn't apply to.
Yeah.
It applies to executory interest, but not
Reversionary interests in general. Possibility of reverter, right of reentry, and a reversion. None of those is subject to the rule against perpetuities. Period, end of story. But in Florida, reverters, which includes possibility of reverter and right of reentry, they're valid for 21 years and only 21 years unless you recreate them. So there's no rule against perpetuities issue, but there is a sunset on them. Yeah. Possibility of reverter and right of reentry. It probably is. And honestly, I kind of like that rule, but I've never seen it tested. Not to say wouldn't be, but I wouldn't say it's real high on the list of what they're likely to test. So speaking of which, you know what? We're all tired. Let's read the facts together. Why don't we just do that? Normally I like to have you go through it first, but it's 10 after 5, so let's take a tour. Let me find it first together. Now, it's an older question. You can see, July 1993. There's a reason why I tend to dip into older questions when I do these classes. I don't like to repeat what you're doing in your commercial classes, and the commercial courses tend to use later questions. So I'm trying as best I can to avoid duplication. So that's, if you wonder why I use old questions, that's why. All right, so we've got Harry and Zelda, an elderly, unmarried couple. Why is that important, unmarried? Okay, no common law marriage in Florida, number 1, and number 2?
No entirety.
No tenancy by the entirety, because you have to be married in Florida to have a tenancy by the entirety. Zelda owns a shopping center. Now, because of her love and affection for Harry, she executes a deed in 1990. Isn't that nice? Do we care that it's for love and affection? Because a deed, it's nice, it's awfully, awfully sweet. But no, we don't really care for the purposes of the deed, because remember, a conveyance of land is analyzed as a gift. 3 elements. You have to have present donative intent, delivery of the deed, and acceptance, which is going to be presumed if the item has value. Now, love and affection might be important if we got into recording, because then we have to talk about value, but for the deed itself, it's irrelevant. So it conveys the shopping center from Zelda, an unmarried woman, to Zelda and Harry, an unmarried man, as joint tenants with right of survivorship. We're going to stop there for a moment, and then we'll read the rest of the sentence. What's Zelda trying to create? What kind of co-tenancy? No? Joint tenancy. Yeah. Now, they're not married. It can't be a tenancy by the entirety. She's trying to create a joint tenancy without the use of a what? Without the use of a straw person. Absolutely correct. Which you couldn't do at common law, right? Because you don't have unities of time and title, because you're taking by different deeds at a different time. Well, there is no Florida Supreme Court case that decides this particular point. There is one second DCA case that says you don't need a straw. I always caution. It's one of the reasons why occasionally I like to do this question, because all your outlines are going to say you don't need a straw. There's a difference. I want to point out the difference. Why I always hedge a little bit here. You want to sound really knowledgeable. Florida has a statute that provides for a tenancy by the entirety, expressly provides no straw is needed to create a tenancy by the entirety. So one individual who owns property may create a tenancy by the entirety with his or her spouse without the use of a straw. You just convey that interest to your spouse. And of course, if parties are married and property is conveyed to them in Florida, we also have a presumption of a tenancy by the entirety. There is no parallel statute in Florida for a joint tenancy. There is no Supreme Court case in Florida that says that you do not need to use a straw to create a joint tenancy. I'm not telling you that you need the straw, because probably you don't. But if you really want to sound like you know what you're talking about, you'll see it in the answer when we get there. You kind of, you draw that distinction. Probably you don't need a straw, but the Supreme Court hasn't said it. The good news in this question, whoever drafted this question knew that there could be an issue there. But once you get past, is it a joint tenancy or a tenancy in common, it comes back together, and the ultimate resolution is going to be the same, whether it's a joint tenancy or tenancy in common. That's a well-drafted question again. So the issue is raised, and at least acknowledge that it isn't as settled as one might love. Okay. Now, after that part of the sentence, notice it says, Harry cannot convey his interest in the shopping center without Zelda's written consent, which is a what? Restraint on alienation. What kind of a restraint? If you remember back to property, some of you, we have 3 kinds of restraints on alienation: disabling, forfeiture, promissory. Disabling restraint says he cannot convey. That's what we have here. Forfeiture says if he conveys, he loses his estate. Promissory, he promises not to convey. Disabling restraint is always void if it's attached to a fee interest, which is exactly what we have here. So that restraint is going to be crossed out. And that's a rule, whether it's Florida, whether it's common law. We're going to see in this question a lot of common law rules that we're going to use. Then we add on top of that Florida rules. Question?
When you say it gets crossed out, does that mean you just convey the property?
Yeah, it is ineffective. That particular restraint is just ineffective, period. Which means Harry can, as he's going to do later, convey his interest. So the conveyance is duly recorded. And then, of course, they fight, they separate, and in retaliation, without Zelda's knowledge, Harry executes a deed conveying his right, title, and interest to his Uncle Frank. Well, guess what? He can do so. And when he does, what happens to the joint tenancy? It's severed. And so now Uncle Frank and Zelda hold as tenants in common. And then Harry dies. When he dies, did he have anything left in the property? No, he conveyed everything he had to Uncle Frank. If he had died before he conveyed to Uncle Frank and we had a joint tenancy, what would happen? Zelda would get the whole thing. But once again, whoever wrote this question planned it out very carefully, didn't want you to have to deal with the question of, does Zelda get the whole thing, or do Zelda and Frank hold as tenants in common? The joint tenancy was severed before Harry died, if there even was a joint tenancy to begin with. Now, here we get some fuzzy facts. It's one part of the question I don't love, but you deal with it. Northwest corner of the shopping center was subject to an easement in favor of Sunshine Utilities, a privately owned power company. It's an easement. It's an affirmative easement, but it's an easement in gross. Utility easements are invariably easements in gross because you have a servient estate, but not a dominant estate. And the good news is, of course, the easement is recorded. Then we've got an encroachment. On the easement, it's not depicted on the survey that Zelda received when she bought the property. There's actually a component here that we won't talk about today, but it's in the answer, dealing with liability for a bad survey, which could be analyzed either under third-party beneficiary, see, contracts goes everywhere, or negligence. In either case, in this case, the cause of action wouldn't succeed. But look what they did. They threw in contracts and torts into this property question. Now, Zelda built a concrete block wall on the property's boundaries and developed the shopping center. And then Sunshine ceases transmission of electricity through the powers, which is making you think about what issue? Abandonment. But for abandonment, you have to have intent and you have to have an act, which they haven't given you yet. They didn't use the lines for power, but did they really do anything like tear down the lines, right? Now, however, the next sentence, guess what? They tear down the lines. Have they abandoned? Probably. And then in 1991, Sunshine demanded removal of the encroaching building, but they already tore down the lines and maybe they abandoned. Now, Zelda flied. Well, I didn't type this question. I'm not sure how it came out, flied. Never noticed it before. Filed. Shows you how important it is to proofread, even if you have spell check. She files a quiet title action to nullify Frank's interest and in the alternative to partition, to sever her interest from Uncle Frank. As a co-tenant, can she seek partition, judicial partition? You bet. Unilaterally, she can seek judicial partition. Sunshine sues Zelda and Uncle Frank to require abatement of the infringement. Well, did they abandon? Now, Frank asks you questions. So here, even though it's an older question, it's a new style question. You answer the questions and you answer them in order. Does he have an ownership interest in the property? Does he have to remove the encroaching building? Is partition available? And if so, who pays the cost? And then the one that we're not going to talk about, his rights against the surveyor. I would encourage you, though, to read what I've included in the answer about the survey, because it shows you again how you can combine topics, and they can test up to 3 topics per question. Even though at the time they gave this question, they were supposed to test just 2 topics per question, you have 3 here. All right, now, to get to Frank's ownership of the property, you have to take a trip back in time, because Frank derived his interest through Harry. So don't just jump right in and talk about Frank. You got to trace through Harry first and go in chronological order. So we go back to Zelda and Harry. Remember, at common law, you need to say joint tenants with full right of survivorship. Remember also in Florida, you cannot create, where do I have it? Well, I don't know, someplace. You cannot create a joint tenancy in Florida without express words of survivorship. So, and which Zelda did here. Absolutely required in Florida, words of survivorship. I just talked to you about the unities. 2 are missing here when you don't use the straw, time and title. Could be problematic. But there is that case, which I have cited someplace here, up here, that says you don't need a straw. So probably, and I don't love waffle words. I don't love, well, it might be this, it might be that. But here I have to say probably the joint tenancy was created. But I'm going to say if it wasn't, then it's a tenancy in common. I'm going to cover my bases again because the law isn't clear here. But whether you have a joint tenancy or a tenancy in common, we still have to deal with that restraint on alienation. The 3 types I talked to you about, disabling, forfeiture, promissory. If you don't remember them from your property class, take a few moments to learn them, if nothing else, for the MBE portion of the exam. That is testable on the MBE. And remember again, it's a disabling restraint. It says he cannot convey. And because it's a disabling restraint, it's probably void. Now, Florida, there is some language in Florida that suggests that Florida uses the modern approach, which looks at 3 factors in judging a restraint on alienation. We look first at duration. How long does the restraint last? The longer it lasts, the more likely the restraint is to be unenforceable. And there's no limit on the restraint in this case. It just says Harry can't convey. Second, type of alienation precluded. The more kinds of alienation that are prevented, the more likely the restraint is to be unenforceable. So, does the restraint say Harry cannot lease? Or does it just say Harry can't convey at all? It's a very broad provision in this case. It means that the restraint, again, is likely to be void. Third is the size of, right there, size of the class precluded. How many people can't take? Does the restraint say Harry can't convey to Uncle Frank? Or does it say Harry can't convey to anybody? It's very broad here again. And notice again, the person who drafted this question is thinking things through. Whether you apply the traditional approach, which says a disabling restraint is void, period, end of story, or you use the modern approach, you get to the same place. The restraint is void, and so Harry can convey to Uncle Frank. Now, consideration. Remember, I just mentioned that. I think probably pretty much everybody knows that. You don't need consideration for a valid transfer of land. It's a gift. And anyway, Harry's deed said $10 and other valuable consideration. It cites the $10. It wasn't given, but we don't care in this case. It's not sham consideration, which you might have to think about in contracts, right? Because consideration isn't required in the first place. Okay, so it's pretty likely that Harry made a valid conveyance to Frank, which leaves Harry and Zelda as tenants in common, regardless of whether Frank and Zelda as tenants in common, regardless of whether Harry and Zelda held as joint tenants or tenants in common. Whichever path you might have chosen, you end up in the same place. So now we go to the next question. We're trying to answer everything they asked. They said we have to decide what the nature of Sunshine's easement was, the encroachment, termination of the easement. As I mentioned, it's affirmative. Easements are either affirmative or they're negative. Affirmative, I have the right to do something on your property. Negative easements, just a note, by the way, because they've tested negative easements in Florida several times. At common law, of course, 4 traditional negative easements: light, air, water, and lateral and subjacent support. And you couldn't have at common law a negative easement for anything else. Florida, however, in several cases, recognizes a 5th, easement of view. Easement of view. Being able to see a lake or something like that, easement of view. But remember, whether it's those 4 traditional ones or the 5th adding in view, a negative easement must always be created how? In a writing. You cannot create a negative easement by implication or estoppel or anything else. It has to be in writing. Here, though, we definitely have an affirmative easement because Sunshine has the right to put its poles on what is now Frank and Zelda's property. It's definitely affirmative. And we need to decide whether the easement is appurtenant or engross. Notice the steps you go through with any easement. What's its nature? Is it affirmative or negative? Is it appurtenant or engross? You have to decide all that up front. Then you're going to think about its scope, then its transferability, and finally its termination. All easements follow that path. So again, first the nature, then the scope, then the transferability, and then the termination. And they love to test easements. And could you have a property question? Yeah, I think you really could have a property question this time. Another reason why I wanted to do this particular question. But here we have an easement engross. Why again? An easement appurtenant, you have both a dominant and a servient estate. I have the right to do something on your property to get in and out of my property, for example. Here we definitely have a servient estate, the shopping center, but no dominant estate because Sunshine is just running its business by running lines across the shopping center. Now.
And the fact that they get the electricity is not a benefit to the Sunshine, or to the...
Well, it doesn't, and it doesn't matter. They're still the serving estate because they have to have the burden of the lines, right?
Right.
And what we now need to look for is a benefit to land owned by Sunshine if we're going to make it an affirmative, an appurtenant easement. Well, Sunshine's not benefiting any land. That's what makes it engross. So Sunshine does have a valid affirmative easement engross. Now, can they force removal of the encroachment? Well, remember that the owner of the easement, and the encroachment is the wall and the building on the shopping center property. It does encroach, but not every encroachment is going to have to go. It's got to be an encroachment that, right there, substantially interferes. And honestly, here's where the facts are a little fuzzy. They didn't tell you exactly how much of an encroachment you have. So I kind of say, if we have a substantial encroachment, then Sunshine has grounds to complain. Because I don't know, I can't tell from the facts. Yep. Okay. Now, remember, we also need to know whether the easement was terminated. And it might be terminated in a couple of different ways. We already kind of mentioned abandonment, but don't forget about this one, which they love to test in essay form, the recording statute. Hard as recording is to do in multiple choice, you also have to be able to write about it on the essay. Ooh. First things first, what kind of statute do we have in Florida? If you don't know it yet, know it now. Pure notice. Make sure you know it because it comes up so often on the exam. So under a notice statute, the interest is not good against a subsequent bona fide purchaser for value who takes without notice. 3 steps for a notice statute that you go through. So, and these 3 steps help you if you're analyzing a multiple choice question as well. But they help you write an essay about something that's hard to write about. So first, you got 2 competing claims. You have to identify who is subsequent. Sunshine took its easement in 1958. Zelda took the property in 79, which is after the easement was created. So Zelda's subsequent here. Zelda with Frank tacking along, of course. Second, that subsequent purchaser has to be a bona fide purchaser for value. Well, it says Zelda bought the property. It doesn't tell you how much or anything like that, but it did say bought, which means she should qualify as a purchaser. And then third, the most important thing is notice. Because did Zelda take the property without notice of that easement? If she did, she took free and clear of the easement. The easement wasn't on her survey, so she didn't have actual notice of the easement. Constructive notice. Was the easement properly recorded? Yes, it was. It said it was properly recorded, so I'm going to have to assume it was recorded in the right place, right? If it was properly recorded, which is what they say, then she should have been able to find it if she'd done a proper search. If she should have been able to find it, then she takes subject to the easement. And inquiry notice. Get some poles and wires and stuff sometime. And again, the facts are a little fuzzy here, but it does say that sometime in 79 they removed those poles and the wires. So maybe Zelda saw them. Not clear, but maybe she saw them. She took the property in 79. If they went down before she took the property, still she probably inspected it before she bought. So she maybe had inquiry notice. At a minimum, she she must have had constructive notice because they tell you the deed was properly recorded. So if she had constructive notice, she takes subject to the easement, at least under the recording statute. But the issue we identified earlier, did Sunshine abandon the easement, causing it to terminate? Remember that storyline that I gave you before with easements. What's its nature, including was it properly created, What's its scope? Is it transferable? And then finally, if it's transferable, is it terminated? And we're talking about termination here. And an easement can be terminated by abandonment. Now, Florida has a kind of funky rule here, because you look at the elements of abandonment, which I said are intent to abandon and enact. Mere non-use isn't enough, but they tore down the poles, right? And they stopped using together. Those two might be enough. So it looks like Sunshine abandoned. But for reasons that aren't clear to me, as I said, Florida has a funky rule. Florida says that in addition to proving abandonment, you have to couple it with estoppel. Usually, abandonment and estoppel are two separate ways of terminating an easement. Florida, in case law, has this funky rule that combines the two. So, for estoppel, and here we're talking about equitable rather than promissory estoppel, because there's no promise. But equitable estoppel may be based on an act or a representation. There's no verbal representation, but what did Sunshine do? They took down the wires, they stopped using the easement. That could rise to the level of a representation. And now the question is, obviously it was a material fact because it could materially affect the value and use of the property. Now the question becomes, is there reliance? And remember, the reliance has to be both reasonable and actual. It seems to be actual because she built stuff on the property. Was it reasonable for her to rely? What do you think? Yeah, I think so, probably. Here, you could say whatever you want, honestly. You could say it was reasonable or it wasn't, and you're still going to be okay. I kind of think it probably was reasonable. And then that means then if you have that representation and reliance that is both actual and reasonable, the final step, would there be injustice in the form of reliance damages if Sunshine is allowed to claim its easement despite the abandonment? And the answer is she's going to have to tear down a wall and buildings and stuff. And so does she have an injustice in the form of reliance damages? Yes. So you have to kind of go roundabout here. Again, a Florida rule that's kind of funky. You go through abandonment, but then you have to add on estoppel. Now, honestly, probably nobody in the room knew that you had to do that, right? If you wrote about abandonment and didn't add in the estoppel, could you still get a passing score? Yes, of course. But now you have a little extra rule there that can pick you up some extra points should they test this particular issue. And it's, yeah, exactly. All these little extra things can add up to the difference between a passing score and one that isn't passing. You're always looking for those little extras. So just pay attention. We're not done though. Adverse possession and prescription, because Zelda's been camping out on that property for some time. Look at all the different ways that you can terminate an easement, and look at all the lovely property issues that this question wants you to think about. Okay, adverse possession, 7 years, and for prescription, 20 years. Now, you still, whether it's adverse possession or prescription, adverse possession you actually possess, prescription you use. We're talking about prescriptive easement. You need actual, open, notorious, hostile, exclusive, right? And then Florida also adds in that I'm not going to spend a lot of time talking about, you have to pay taxes, right? That if you don't have color of title, you have to pay taxes. And by the way, did Zelda have color of title here? Yeah, she had a deed, right? Yeah, she did. So she wouldn't have to pay the taxes. So, actual, open, and notorious. Yeah, you got a shopping center sitting out there in the middle of the easement. That's pretty actual, open, and notorious. Hostile. You're going to use the objective test here in Florida, and yeah, there was no consent, and so all she has to do is build as long as it's not permissive, which it clearly wasn't in this case. The exclusivity element is relevant. It's the one place, well, one of two places where prescription and adverse possession differ. Because adverse possession, the possession must be exclusive. You can't share it with the owner. Exclusivity is pretty much a non-issue when it comes to a prescriptive easement. You can and oftentimes do share a prescriptive easement with the owner. And then, of course, in Florida, some additional requirements. If you have color of title, which she did. Oh, what time does your class start?
Sorry.
Oh, okay. Okay, they're good. Okay. Yeah. I thought we were okay time-wise, but what do I know? Look what you have to do. You have to cultivate, which she clearly didn't do here. It's a shopping center. Or if you have an improvement, it must be enclosed. She built a wall, right? Or you have to use it for supply of fuel or fencing timber for husbandry, your own use, using the trees for your own use. But she made an improvement, and it was enclosed. So she had color of title, because she had a deed, and she enclosed and she improved. So she's probably okay. Then again, I just threw in there, not relevant here. Without color of title, as you knew already, you have to pay taxes. Has to be continuous for the period. Statutory period for adverse possession in Florida is 7 years. So remember that, because they do like to test adverse possession. For a prescriptive easement, you use in Florida the common law 20-year period. And Zelda's been there for 12 years. So if it's adverse possession, which it probably is, we're good enough. So what's my conclusion? That easement's dead. One way or the other, it's dead. And because it's dead, Sunshine really can't force Zelda and Frank to remove the building. Now, one last point. And then, again, I'm going to leave the action against the survey for you to look at yourself. Partition. We got to determine whether the court will grant partition, and then they actually ask you who bears the cost of the partition suit, which fortunately is not a specific Florida rule, but it's probably also not one that you learned in your property class, including my property class, for those of you who had my class. Partition, any co-tenant has the right to partition. And I find it very interesting. They have included co-parsoners. Nobody has co-parsoners anymore. There must be some historical reason for that. Co-parsoners at common law were female heirs who took the property because there were no male heirs. And they took as what was called co-parsoners. I'm sorry?
They kept it in?
Yeah, it's kind of peculiar. I put it up there because that's what the statute says. I wouldn't worry too much about it. Now, if you seek judicial partition, you go to court, and as I said before, any co-tenant has the right to go into court without the consent of the other co-tenants, joint tenants, tenants in common. Not tenants by the entirety because you can't partition, but joint tenants, tenants in common, seeking partition. And the court is going to partition unless it is an extreme case. Partition in kind is the preferred partition. This property, I don't know whether you could partition it. So it's kind of interesting because it doesn't tell you where the buildings are. But of course, if physical partition isn't possible, then the court will award partition sale. One way or the other, Zelda's going to get her partition. And what do you think? Who pays the cost of the suit? All co-tenants. Yeah, all co-tenants do. Even though Zelda forced Frank into court, Frank's going to have to pay as well. You might not think that's fair, but yeah, that's the law. Okay, any questions about this part? Again, I suggest you take a look at the survey because it's actually interesting. Takes you through third-party beneficiary law again, or maybe for the first time, and also negligence. Okay, that's it for today. Tune in on Monday for civil procedure. May not be your favorite subject, definitely not my favorite subject, but you guys know that you are going to be tested on federal civil procedure. So we'll see you all on Monday, 3:30 in,
3:30 on Monday?
I think it's, what room, Natalie? Here, 3:30 Monday here. Okay, have as good an evening as you can. For those of you who are doing your midterms right now, some of you may have already done them. The rest of you are doing it this weekend, right? Yeah, some are, not everybody. For those who are, good luck. I'm sure you'll do great. Okay, we'll see you Monday.
They send the bar our transcripts and stuff.